Strang.
My lords, my lady, yes, I appear for the appellant in the first number of your appeals. That's Dr. Abdulla, and I appear with Kal Taklal Singh and Stefan Ramkassoon of the Trinidad Bar, and we're instructed by Joanna Richards of Sovereign Chambers in Trinidad. And for the respondent in my appeal, that's Aeden Balwah, Dr. Powers, KC, appears, and he's instructed by Killian Moran of Simons Muirhead and Burton. He would have been accompanied by Rajiv Prasad, Senior Counsel of Trinidad, who's detained by a case in Trinidad, sends his apologies. And the clinic, Surgi-Med, who's the respondent to Aeden Balwah's appeal in the second of the numbered appeals, is represented by Ben Brown, KC, and Finn Callow, and they're instructed by Narad Harikassoon and Andre Sinanan of Harikassoon and Company in Trinidad.
Thank you.
My lords, my lady, by way of introduction, I'd like to first explain the issue and the finding which determined the case at trial, and then summarize my two main arguments as to why the Court of Appeal erred in setting aside the judge's finding and the judge's decision before I go into the details of the chronology and the findings. And I'll refer to my client as Dr. Abdulla. I'll follow the nomenclature in the cases, so I'll refer to the respondent as Aeden, and I'll refer to Surgi-Med as the clinic. Aeden's case was that his cerebral palsy was caused by a brain injury suffered during his mother's labor as a result of negligence of Dr. Abdulla and the clinic. And this brain injury was said to have been caused by a prolonged interruption of the flow of blood to Aeden's brain, causing a lack of oxygen. And that's known as PPHI, partial prolonged hypoxia ischemia. And it was said that this interruption was caused by the physical effects upon Aeden and his mother of Dr. Abdullah's negligent treatment. And it was said that this interruption went undetected because of inadequate monitoring of Aeden's fetal heart rate. So the claim raised a number of issues as to the nature of Aeden's brain injury, when it was suffered, how it was suffered, that is, the mechanism by which the injury was caused, and whether the negligence of Dr. Abdulla and the clinic played a causative role. And all of those entailed a large number of factual questions for the judge. But before those questions could be addressed, a threshold issue was identified, which arose from the necessary conditions that had to be in place for Aeden's injury to have occurred in the way that he claimed. And the necessary conditions were these. First, the expert evidence established that for any interruption of oxygen to cause a brain injury of the kind posited by Aeden's case, the interruption would have to be prolonged for at least an hour. And second, during such a period of prolonged interruption, a fetus would show signs of distress, in particular, an elevated or irregular heart rate. But all the recorded measurements of Aeden's fetal heart rate in the medical notes showed a normal heart rate. So in order to establish that it was even possible for the claimed injury to have occurred during labor, it was necessary to identify a period of longer than an hour when Aeden was at risk and where there was no record of fetal heart rate monitoring. And the only probable candidate for that period was the period between the end of active attempts at vaginal delivery and Aeden's eventual delivery by caesarean section, because no record of fetal heart rate monitoring appears during that period. Now, Dr. Abdulla made a note at the end of the active attempts at delivery, recording that Aeden's heart rate was regular.
The note was made at what point?
That was at the end of the active attempts at vaginal delivery.
Yes.
But there's no record after that. And delivery by caesarean section came sometime later at 6:15 a.m. And this is where the decisive issue arises. Because if the active attempts ended at 5:30 a.m., as I say Dr. Abdullah's note indicates, then the remaining period before delivery at 6:15 a.m. was only 45 minutes long. And that's not enough time for the injury to have occurred. And it's common ground, if the attempts ended at 5:30, that Aeden's case is impossible. Common ground on this issue. On the other hand, on Aeden's case, if the active attempts ended at 5 a.m., then the period of 75 minutes before delivery would be enough time for him to have suffered the claimed injury. So his case becomes possible. I say possible, but not proven. More would be needed to go on and prove the case. And after trial on this issue, the judge found that 1 hour of active attempts took place from 4:30 a.m. to 5:30 a.m. And therefore, Aeden's case was bound to fail. And he found that he did not need to go on to consider the further questions that would otherwise arise. That's how I summarize the issue and the judge's finding. These are my two main arguments on appeal against the Court of Appeal's decision. First, the judge made a finding of fact about the time of active attempts, and he was entitled to make that finding, which was supported by the documentary evidence. And I say the Court of Appeal had no good ground for interfering with that finding. It purported to identify 3 errors on the part of the judge. Each of those was wrong in my submission. 2 of them derive from an analysis of the evidence by the Court of Appeal, which was itself, I say, wrong. And the third supposed error was that the judge ought not to have made a finding inconsistent with Dr. Abdullah's pleaded admission as to the time of the active attempts at delivery. And I say that was a matter for the trial judge, and the Court of Appeal did not, in my submission, identify good reason for saying that the judge had gone wrong and wasn't entitled to make that finding. So that's on the finding of fact. Second is the question of proof of injury and causation. Because even if the Court of Appeal was entitled to interfere with the judge's finding of fact, it was wrong to find that Aeden's claim was inevitably proved as a result. And I say respectfully that it thoroughly misunderstood the claim, the issues as to causation, and the judge's findings. Because as I say, the judge found the injury to Aeden could not have occurred during labour and therefore could not have been caused by the defendants. As a result, he didn't need to go on to address the other questions that would have arisen for his determination if the injury could have occurred during labour. And I say his judgment's clear about that. If his finding on time is reversed, it means that Aeden's injury could have been suffered at the relevant time. it would then have been for the court to determine whether a relevant injury was suffered at that time, what was the probable cause and mechanism of injury, and whether the defendant's negligence played a causative role. The judge didn't make any of those findings. So the Court of Appeal was wrong to say that a finding in Aeden's favour inevitably followed. So I'm going to start with chronology and then the details of the judge's findings. And I'm planning to tell the story via the medical notes. The judge accepted the accuracy of the medical notes. And so we'll start at page 437. And this is the admission to the clinic of Aeden's mother on the 18th of May, 2002. And so she's approaching her 41st week of pregnancy, and she attends the clinic on the 18th of May at around 7:30 p.m. for a planned induced birth. And you can see at the top of the page that on arrival, Aeden's fetal heart rate is measured. And then we have the notes of...
The plus R means 148 beats per minute plus R.
Plus R, I'll have to...
Well, don't leave it be. It's okay.
Oh, regular.
Regular. Yeah.
Thanks. As it happened, Aeden's mother said that was the only time Aeden's heart rate was measured. So her evidence, her oral and written evidence, was that none of the other recordings of Aeden's fetal heart rate took place. But the judge rejected that evidence. So going on to the timetable, we can see 18th of May, 8 p.m., we see under the main column, pains duration frequency, there are no contractions yet, nil. And then FH is fetal heart rate. And then the final column, that's the Dr. Abdulla administering misoprostol. And the judge found that to be Dr. Abdullah's sole breach of duty because he administered a dose in excess of what the judge found to be the standard in Trinidad and Tobago. And the possible effects of an excess of misoprostol are what's called tachystole, which is excessively frequent contractions or excessively prolonged contractions, or hyperstimulation of the uterus. And if those occur, they're capable of interrupting the blood flow to the fetus. So that would be the mechanism of injury via excessive misoprostol. And we see on this page, there's no further entry until 12:30 a.m. on the 19th, when contractions begin. So that's 1 every 15 minutes, mild to medium, and a fetal heart rate of 144, again with the R. And the clinic's explanation for the lack of records between 8 p.m. and 12:30 a.m. was that Mrs. Balwah had not gone into labour yet. So then we see the frequency progressing over time. At 1:30, 1 every 12, fetal heart rate measured. 2:15, 1 every 12, moderate. What you can see in the final column at 2:15 is that Dr. Abdulla was informed that the mother wasn't tolerating the contractions, and so he prescribed Trebalin, which is a tramadol. It's an opiate analgesic. And then 3:30 a.m., the contractions are more frequent now, 1 every 10 minutes, fetal heart rate measured, regular, and membranes have ruptured. And there's measurements of the cervix. And then 4 a.m., now
So
it's
the draining clear liquor there at the bottom of that.
draining clear liquor, yes.
Yes.
And then at 4 a.m., 1 every 5 minutes, moderate. Again, fetal heart rate 136, regular. And the next page, we have to go on.
So these are all the midwives' notes?
These are the midwife's notes. These were made by Nurse Hoston. She couldn't give evidence at trial. She'd passed away even before the claim was issued. To see the last of these entries, we have to go on 2 pages to 439. It's the last of Nurse Hoston's entries. 4:30 a.m., 1 every 3 minutes, now moderate to strong, fetal heart rate 136 regular, and this is an important entry, OS fully dilated. And here OS means opening. So the cervix is fully dilated. This is a key record, and it was a key piece of evidence for the judge, because it's not until the cervix is fully dilated that attempts at delivery begin. And after one has started attempts at delivery, one no longer measures the dilatation of the cervix. And we can see...
Do you monitor the fetal heart rate?
Yes, but it's now being monitored by a different way during delivery. So Dr. Abdullah's evidence was that once active attempts at delivery started, the midwife would be measuring the fetal heart rate between contractions and reporting it to him orally.
What's the name of the device that's used? No, not to worry.
A Doppler device.
A Doppler. Well, is a Doppler mechanical, or is it literally just listening? Because I thought there were 2 types of devices, one mechanical and one just listening. There's a
There's an explanation within the notes, and the answer is there's a microphone. The Doppler is put onto the abdomen, and there's a microphone, so there's an oral readout, if I can put it like that, and there's also a screen. So it's as it were, a 2-fold monitor.
Okay, thank you.
It's dealt with in Dr. Abdullah's evidence. I can take you to it in due course if need be.
Thank you. So, regarding the cervix being fully dilated, we can see the judge confirming his understanding of this entry in a cross-examination of the expert witness, Mr. Jayasimi, who was a consultant obstetrician, and instructed by Aeden. And we can see it if we turn now to page 1723. And the judge's questioning begins at line 23. And you can see at line 29, he refers to the entry which shows that the cervix was fully dilated. And he asks the expert obstetrician some questions about that. During the attempt, you wouldn't measure dilation. The witness over the page, we wouldn't mention it, you wouldn't measure it. And the witness, no, you wouldn't. Okay, no, because it's already fully dilated, yes. So the judge is confirming his understanding of that entry. You wouldn't measure dilation of the cervix during attempts at delivery. Attempts at delivery begin once the cervix is fully dilated. So the next page I want to look at is Dr. Abdullah's note of the events of this night. because it's some time around now, and this was in dispute, that Dr. Abdulla arrives. So his note is at page 441. And you can see it begins at 8 p.m. on the 18th with the administering of misoprostol and cervical examination. And then he recommends bed rest, but the critical entry is at the bottom of the page. 19th of May, 4 a.m. is in the left-hand column. And by the way, for reference, there's a typed-up transcript of this at 2624. So, called out to see patient who's fully dilated. And then we can see that the note is actually written after further events after that, because the next entry is vaginal delivery attempted for 1 hour without any progress. So it appears to be written after that 1 hour of attempts. Then we see fetal head descended up to the level of the spine. And then it's got caput plus plus, which is a description of the shape of the head. It's an observation of the shape of the baby's head as it comes under pressure. And then we have no MSL, that's no meconium stained liquor. If that was present, it could be a warning sign. And then we see FH regular, that's fetal heart rate regular. And then we see episiotomy given to facilitate delivery. And then, importantly, over the page, at the top of 442, no progress, POP transverse, I believe that's a reference to a prolapse, POP. And then 5:30 a.m. for LSCS stat. So LSCS is lower segment, cesarean section. So that's 5:30 a.m. decision to go for a cesarean section. And stat, I believe it's agreed that says stat, which means immediately. So in my submission, this is another important note. Events are said to begin at 4 a.m., but it's written at the end of a series of events at, I submit it's to be inferred, 5:30 a.m., when Dr. Abdulla takes the decision to resort to cesarean section, because no progress had been made at vaginal delivery. And it indicates that 1 hour of attempts at vaginal delivery ended at 5:30. That's when the decision is taken to try no more and to resort to cesarean section. And of course, that also indicates the hour began at 4:30, which is consistent with the previous note that we saw recording the cervix fully dilated at 4:30 a.m. So in my submission, the right interpretation of these two records, 4:30 a.m. fully dilated, 5:30 a.m. decide to resort to C-section, is that 1 hour of active attempts took place from 4:30 to 5:30. And the note recording the time at 4 a.m. is, as Dr. Abdulla suggested, likely to refer to the time he was called by the clinic to come over and assist with the birth. And that interpretation of the notes was put to Aeden's consultant obstetrician expert, Mr. Jayasimi, and he agreed with that interpretation of the notes. You can see that in his cross-examination at page 1549. So I'll just ask your lordships and your ladyship to start at line 13, and you can see Mr. Jayasimi taken through the chronology as it appears from the notes. And line 25, attempted for 1 hour. Yes. Line 27, 4:30 to 5:30. 28, that's correct. So that interpretation of the notes is endorsed by the claimant's consultant obstetrician. So now I'd like to show you the notes of at the time of delivery by C-section. And they will begin, well, the first note I'd like to take you to is 438. So this is the clinic's note. Clinic's page of notes here. There are 2 entries about the caesarean section. At the top, we see 19th of May, 6:15 a.m. Emergency caesarean section extraction, live male infant by Dr. Abdulla. And then suturing. Then the 3rd entry on the page, infant notes. Again, we see caesarean section, male infant, time of birth 6:15 a.m. Scored APGAR, and that's an important entry, 3, 5, 10. So the APGAR score measures 5 factors, which are appearance, which is the color of skin, etc., pulse, grimace is G, which is the infant's responses, and activity is A, muscle tone, etc., and R is respiration. So each is marked 0, 1, or 2, which means 10 is a perfect score, and they're marked at 1, 5, and 10 minutes after birth. And in this case, Aeden had to be resuscitated upon birth, and you can see that's, I think that's referred to there at the bottom, seen by Dr. Aguilar. But he scored APGAR of 3 at 1 minute, 5 at 5 minutes, and a perfect 10 after 10 minutes, indicating that he recovered quickly from what Dr. Aguilar described as mild birth asphyxia. So there's another clinic note at 453.
Sorry, 453.
453.
Thank you.
Again, same time. Newborn male, recording caesarean section, and the reason, failure to progress. And then the APGAR score recorded again, birth weight 3 kilograms, and then off to the right, resuscitation, the means by which he was resuscitated. And then just a little bit lower, you can see what I think says mild respiratory distress.
Just remind me, whose note's this?
These are the notes of the clinic. So
And we don't know who.
I don't know who. I'm sorry, I don't know. The doctor's note is at 442, Dr. Abdullah's note. So he records the C-section delivery, and he records fetal head had to be pushed by one of his assistants because the head was deep into the pelvis. Delivery of full-term male infant APGAR 3-5. I'm not sure there's anything else relevant there.
Are there transcripts of all of these notes, or just the note at 441?
I'll check that. I'm not sure that all of them have been transcribed.
Right. If there are, it'd be helpful.
See what we can do, yes.
Thank you.
Right, and the last note I want to show the board is at 471, because later that day, Aeden was transferred to San Fernando General Hospital. He was referred by the clinic's pediatrician, Dr. Aguilar, and this is his referral letter. So this is later in the day on the 19th. And kindly admit, I'm not sure what the next word says, kindly admit this infant with birth asphyxia, now observed to be having mild twitching of extremities. And then some details. Born 19th of May, 6:15, by cesarean section for failed induction, prolonged second stage. That was relied on by the Court of Appeal. We'll return to that. Prolonged second stage. APGAR 3, 510, and then to the right of that, resuscitation and the means of resuscitation. And then we have birth weight, and then I think that's the mother, 25 years, prima gravida, that's first pregnancy. So that's the reference to hospital. So those are the relevant notes of the events of the birth, and I'll now turn to the judge's findings. His judgment begins at page 29. And he recites the evidence at some length. I'm not going to go through all of the judge's recitals of the evidence, but I will pick out a couple of points that he makes during recounting the witness's evidence, which he then refers back to when he's making his findings. Because one point made by the defendant's experts and put to the claimant's experts was that those APGAR scores that we saw were inconsistent with a recent injury of the severity of PPHI, of the prolonged lack of oxygen for more than an hour immediately before birth. We can see the judge adverting to these points, for example, at page 47, paragraph 48, when that was put to Dr. Milligan. Dr. Milligan was the claimant's expert neonatologist. So what he records some of the clinical observations after birth being inconsistent, was put to him that they were inconsistent with such a severe injury immediately before birth.
Paragraph 48 refers to a consensus statement. That's not a document I was able to locate in any of the electronic bundle.
If I can find a reference. It's referred to as a consensus statement of a medical association or medical grouping of experts as to what one would have to see if there had been such a prolonged hypoxic event immediately before birth. Oh, you have to.
Yes, it's page 2437 is the document.
Thank you.
Thanks. Thank you very much. Yes. So there, for example, was the APGAR score being put to Dr. Milligan. In fact, the judge, I think, records that twice, because he also records it at paragraph 62 at page 51. It may be that both cross-examiners put it to him. So again, these are the essential criteria, including the APGAR scores. And then, referring to the same point, the judge refers to Dr. Abdullah's expert, Dr. Wilkerson, whose evidence about the unlikelihood of the injury happening immediately before birth is summarized at paragraph 93. And over the page, his detailed observations on the APGAR score at the top of page 62. And finally, at page 66, paragraph 107, this is Dr. Abdullah's expert obstetrician, Dr. Sinkhorn. And the reason I'm referring to these APGAR scores in particular is because the judge makes reference to them in his findings. There's a lot more about causation and proof of injury in the judge's assessment of the evidence, which I may come back to later. But the judge's analysis and findings begin at page 69. And he begins by discussing the pleading point, the pleading issue. Now, this may be a good time to very briefly show the specific admission that led to the dispute. I will discuss the pleadings in considerably more detail later, but just for the purposes of right now, this is the admission that active attempts at birth took place from 4 a.m. to 5 a.m. And that's the relevant pleading begins at page 226. This is the amended statement of claim. Paragraph 18, the claimant avers the following significant events, and then goes through a chronology. And the particular pleading that led to the admission is 227 G and H. There's the timing. And Dr. Abdullah's defense and his response to those particular pleadings, G and H, is at page 278, paragraph 22. And then the clinic's defense, clinic's amended or re-amended defense, is at 338.
Sorry, it was 278, paragraph
22.
22, thank you. Yes, got it.
Sorry, could I have the page number for the clinics again?
The clinic's is 338.
Thank you.
And it's G. So this is the clinic's re-amended. As to, see at the bottom, as to subparagraphs G and H, and then the timing of the attempts at delivery is over the page at 2. Vaginal delivery was attempted for an hour before 5:30 a.m.
So that's the amended defense.
That's the clinic's
Amended defense.
Yes,
Yeah. The initial defense was it just admitted it.
that's right. Yes, my lord. This was the re-amendment made at trial, to which the claimant did not object. The judge permitted that re-amendment. So, returning to the judge's discussion of the pleadings, page 69, paragraphs 119 and paragraph 120. That's what he says about how he's going to deal with the difference between Dr. Abdullah's evidence and his pleading. And I think we can agree that at the beginning of paragraph 120, there should be a not between may derogate. At least that's how the judge put it when he gave his oral judgment. But then he goes on to say in what circumstances he will allow a party to derogate from its pleading. So that's what he says about the pleadings. His findings begin at page 74. So paragraph 129 is the clinic's standard of care. Paragraph 130 over the page is Dr. Abdullah's standard of care. And then the findings of breach are at page 76. So at the bottom of paragraph 133, at the bottom of 76, that's the one breach found against Dr. Abdullah, an excess dose of misoprostol. And then over the page, the judge refers to the question of causation. He says there is great dispute among the parties. That's paragraph 135. And then he goes on at paragraph 136 to identify an important factor. And you can see he refers to Dr. Wilkerson, whose evidence was that injury probably happened before labor, in the weeks before birth, but not during labor or delivery. And the judge notes that if that's the case, it couldn't have been caused by the negligence of either of the defendants. It wouldn't matter that there was an absence of recording or an excess dose of misoprostol. And then he goes on to advert to three parts of the evidence which may be relevant to that particular consideration. Over the page, at the top of page 78.
The Court of Appeal seems to have read paragraph 136 as a finding that these two breaches weren't causal.
Yes.
Rather than, as you read it, as the prelude to examining if the causal link would have been possible.
I do say the Court of Appeal misunderstood some of the issues as to causation and the findings of the judge. And as far as I can see, the Court of Appeal's approach to proof of injury and causation, as it's laid out in their judgment, is no longer supported by Aeden's case. But we'll get to that in a minute.
But at this point, at 136, the judge is considering the matter in the context of the alleged overprescription of misoprostol.
Yes, exactly. That's the only breach the judge finds. Which we'll see is another error of a misunderstanding by the Court of Appeal when we get there. But the judge identifies three things occurring to him, it appears, which are relevant. Some evidence about whether injury happened immediately before birth. And you see A is the APGAR score point. That would cast doubt over whether the injury happened immediately before birth. And then the CT scan is, the judge records that as being neutral about when the time of injury was. And then he raises the lack of any evidence of fetal distress, which casts doubt over whether anything the defendants did caused injury to Aeden. I take it that's why he's referring to these there as factors relevant to the issue he's just identified. But he doesn't go on to decide any of those matters, because he goes on to explain that timing issue, which I identified at the start of these submissions, and that's at paragraph 139, at the bottom of page 79. So he starts, he says, the half-hour difference between the parties is critical. And that's the half-hour difference I explained at the beginning. When did the active attempts end? Did that leave enough time, unmonitored time, before delivery by C-section for an hour of injury to have occurred? But the judge expresses it by the beginning of by when the beginning of that 1 hour
rather than the end, because the critical time is 5 or 5:30, really.
Yes, the critical time is the end. We can see later on the judge is talking in terms of a 1 hour period. He expressly says a 1 hour period later on. So then he goes on, his findings as to timings. Paragraphs 140 to 142, he explains why he finds the oral evidence unreliable. It's hardly surprising when these events took place in 2002, witness statements were made in 2016, and trial was 2019.
There's another no missing from 142, isn't there?
He has no recollection independently, yes. Yes, that's right. Yes, so the judge then turns to the notes, and he begins that. He begins discussing the notes at the bottom of paragraph 142, and then 143, and he says actually that Dr. Abdullah's note that begins 4 a.m. doesn't help him to decide what the 4 a.m. timestamp meant and when Dr. Abdullah arrived. And the note that really helps him is the 4:30 entry. And he turns to that at paragraph 145.
Just before leaving 142, the judge says that Dr. Abdullah's evidence, insofar as it relates to matters that are not in his notes, is also unreliable.
Yes.
Was there anything in his notes about requiring constant fetal heart monitoring between 5:30 and 6:15?
No.
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 But he gave evidence that it was being monitored,
He did.
and that evidence is unreliable.
Yes. The reason why it was accepted that the period after the active attempts was the probable period was precisely because there's no record of monitoring during that period, whether 45 minutes or an hour and 15.
Yeah.
Dr. Abdullah does record fetal heart rate regular at the end of the active attempts.
5:30, yes. Yeah. But any evidence as to fetal heart monitoring between 5:30 and 6:15 is unreliable, is that right?
That's correct. Yes, that's how the judge found it, yes. So the critical note for the judge is the clinic's record, and he discusses that at paragraph 145. And this is the note fully dilated at 4:30 a.m. He accepts that as a correct note, even though in other respects he says the midwife didn't record everything she should have. He accepts that note as accurate, and he says, at 4:30 a.m., if the claimant's mother was in the middle of an hour-long attempt for vaginal delivery, it's less likely there would have been a measurement of her contractions and a note she was fully dilated at that time. And that's why he draws the conclusion that the assertion of attempts at delivery beginning at 4:30 is more likely than not what actually happened. And just to confirm a point there that we just discussed, the judge is here expressly concerned with an hour-long attempt for vaginal delivery. And he's deciding when that hour started and finished. And then the consequences for Aeden's claim are set out at paragraph 146. So the injury couldn't have occurred during labour and delivery, which disposes of Aeden's claim. And then, importantly, paragraph 147, this is a critical statement of the judge when we come to see how the Court of Appeal dealt with proof of injury and causation. It's not necessary for me to take the further step and consider further whether the breaches of duty actually caused the damage, as it's not possible for them to have done so. So the judge is expressly declining to make any further findings about proof of injury and causation. But concentrating for the time being on the judge's finding at paragraph 145, I say he was entitled to make that finding. Indeed, I say he was right, for the reasons I've attempted to demonstrate on the documentary evidence. It's the right interpretation of the notes in my submission. So, that said, I'll now turn to the Court of Appeal. Because in my submission, the Court of Appeal wrongly overturned the judge's finding of fact. And their discussion of the finding of fact begins at paragraph 170, page 126.
Sorry, page?
Page 126.
Page 126, thank you.
Paragraph 170 and 171 summarize the judge's approach. And then the 4 a.m. note, or the 5:30 a.m. note, which, as I would put it, is reproduced there at paragraph 172. There's an important bit of information missing there, though, from the Court of Appeal's summary, which is the information over the page that we saw at page 442, the entry about no progress, POP transfers, 5:30 a.m. LSCS stat. The Court of Appeal has not included the rest of the note over the page, which I say is an important omission. And so, paragraph 173, they transcribe the first part of the note, but miss out the end of the note. And then at paragraphs 176 to 179, the Court of Appeal elucidates what it says is the judge's error. In his interpretation of this note, he points out that he is inferring from that note when attempts at vaginal delivery commenced. And the error in the Court of Appeal's judgment is described at paragraph 179. The judge's finding was based on an inference that it was unlikely that Mrs. Balwah would be checked for contractions in second-stage labour. In our view, the judge was not correct to make this inference. He did not indicate the premise upon which he inferred that there would be no measurement of contractions intrapartum. This is entirely a matter for an expert as to protocols normally followed in the management of second-stage labour. The judge was unquestionably unqualified to make such an inference. In my submission, that is an error by the Court of Appeal. It's true that the judge didn't expressly indicate this in his reasoning, but we have seen that he was relying on the evidence of an expert for this inference. Mr. Jayasimi, the expert obstetrician, confirmed the position for him. He wouldn't be measuring dilatation in the middle of attempts at delivery. And delivery starts after full dilation. So the Court of Appeal, in my submission, is wrong there to hold that against the judge.
Did the other obstetrician give evidence on that matter?
Not that I have seen.
Because, of course, the judge wasn't impressed by that, by Dr. Jayasimi.
Dr. Jayasimi. Well, he wasn't impressed because Dr. Jayasimi, he found, was arguing the claimant's case a bit too strongly. So, but where Dr. Jayasimi concedes something against the claimant's case, he may be more inclined to rely on it.
And this wasn't an answer to cross-examination. This was an answer to a question
Yes,
from
the judge
himself.
Yes, at the end of cross-examination, yes.
Yes.
Well, I think during cross-examination. I don't think it was at the end.
So, yes, it was after cross-examination, before re-examination. Yes. So that's, in my submission, the first error of the Court of Appeal. The second is the next paragraph, paragraph 180. The judge failed to take into account the referral letter of Dr. Aguilar, who wrote that second-stage labour was prolonged. There must be much evidential value in this note since it was made mere hours after the appellant was born, etc. Material error to have omitted to consider this, and the same point is made at paragraph 184. Now, I do say this is an error. First, the Court of Appeal does not explain why this contradicts the judge's finding as to a timing of 4:30 to 5:30. And it's important to note in my submission, Dr. Aguilar was not present during labour and delivery. He didn't give evidence to the court as to what he meant in his note to the hospital. And the only evidence before the court about what prolonged second stage amounts to in medical terms was in Mr. Jayasimi's report. We can see that at page 808. At the bottom of the page, second stage should be no longer than 3 hours in nulliparous women. So for a first pregnancy, 3 hours is the guidance for a second stage. I infer that when he goes on to say prolonged second stages are associated with adverse outcomes, Mr. Jayasimi is defining prolonged as longer than 3 hours for a first pregnancy. So without Dr. Aguilar explaining what he meant, it's difficult to see in my submission how his note that second stage was prolonged could amount to a reason not to accept the evidence of the contemporaneous notes of those who attended the birth which clearly, in my submission, demonstrate active attempts from 4:30 a.m. to 5:30 a.m. The Court of Appeal doesn't explain why Dr. Aguilar's note must be treated as inconsistent with that.
It's for the trial judge to decide what, if any, weight to give to this piece of evidence.
Indeed, my lord. And it's also well known, for example, in the Volpe and Volpe case, that in the summary of principles in the Volpe and Volpe case, that just because a judge doesn't refer to something in his judgment, should not lead to the inference that he didn't consider it and give the weight he thought appropriate to it. Oh, I'm very grateful to my learned friend. Page 33, at the bottom of paragraph 7, the judge does record Dr. Aguilar's note as part of the evidence. He does refer to the observation of a prolonged second stage.
Sorry, that's...
So he refers to it in his account of the evidence at paragraph 7, page 33. He doesn't refer to it in his reasoning, but he was well aware of the note and what it said. And then the third error, I say, of the Court of Appeal is I'm returning to page 129. The judge had no regard to the pleaded admission of the second respondent. Well, first of all, the judge did have regard to it. He explained what his approach was going to be. But the Court of Appeal finds against the judge because it holds him to the standard he expressed. If there's clear evidence, I won't consider myself bound by it. And the Court of Appeal says there was no such clear evidence. Well, in my submission, that's wrong for the reasons I've already attempted to show, that the documentary evidence is clear. 4:30 to 5:30 a.m. And I would say it's difficult to see on those documentary records how the judge could have found that attempts went from 4 a.m. to 5 a.m. as opposed to 4:30 to 5:30. But in any event, I say the judge was entitled to make that finding. And what I propose to do now is turn to the law on departing from pleadings at trial.
Sorry, just on the clear evidence point, I think the trial judge did at paragraph 150 of his judgment refer to the claimant's case being stymied at the end of the day by the interpretation of a record which was unclear at best. So I think that's one of the arguments against you, is whether the evidence was clear.
Yes.
The trial judge having set that as the standard.
I accept that. What I have attempted to show is that those two critical notes really can't be interpreted in any other way. It began at 4:30 and it ended at 5:30.
That remark was made in the context of costs application, which was somewhat different.
Yes, that's true. The judge did remark on certain absences of documentary evidence in other aspects. But on the timing, I say, those two notes are critical, and they really can only be read in my submission in one probable way. So, before I expand on why the judge, I say, was entitled to make that finding, notwithstanding Dr. Abdullah's pleaded admission, I would just like to state what I say is the relevant principle of law, which is that the trial judge may always permit a departure from a pleaded case where it's just to do so. And in my submission, that principle applies in Trinidad and Tobago as much as in England. It's true that conditions under which amendment of pleadings are permitted under the CPR of Trinidad and Tobago are different and somewhat more restrictive than the CPR in England. But the relevant proposition here is the general one. The trial judge may permit a departure from the pleadings where it's just to do so. In my submission, that's an orthodox statement of one of the powers of the trial judge. And it's of general application. I will refer to two English cases about this. The first is Ali and Dink, or Dinch, I suppose, which is at 2963.
2963.
2963, yes.
Thank you.
And this appeal concerned a case where the trial judge had adopted a case that was not advanced by either party. But the court, when discussing the law about pleadings, also confirmed general statements of principle about departure from pleadings. And the discussion begins at 2967. And the first case was referred to as another one where the judge advanced a theory not advanced by either party. But I'm interested in paragraph 23 in particular, which is a recital of what Lord Justice Nuji said in the case of Satyam.
Sorry, paragraph 23?
Paragraph 23, which is 2968. So, confirming this citation confirms the importance of pleadings, confirms that it's unsatisfactory when one or other of the parties runs a different case at trial from that pleaded. And then the reason why it's important to plead, so the parties can know the issues which need to be addressed in evidence and submissions, etc. The court can know what issues. But here's the statement of principle, which is affirmed again in Ali and Dinch. Trial judge can always permit a departure from a pleaded case where it's just to do so, although it would be good practice to amend. Loveridge and Healy I'm going to come to. And then the Court of Appeal in Ali and Dinch discusses the statements of principle at paragraph 25. The relevant principles applying when a party departs from pleadings. So it's, prejudice is the primary factor. So that's why the function performed by pleadings is an important one, but it's also why a judge can always permit a departure from a formally defined case where it's just to do so. It's also why the judge's function is to try the issues the parties have raised before them, rather than reach a conclusion on the basis of a theory which never formed part of either party's case. And then points out that the court is placing the emphasis on prejudice. And the other case I would like to refer to is that of Loveridge and Healy, which is at 2973. This was a case about the termination of a license agreement, and the claim depended upon notice having been given. And the defense admitted the pleading about notice, although not perhaps as clearly as it might have done, when in fact no valid notice had been given. And I pick up the Court of Appeals discussion at paragraph 23, which is 2981. I won't read it all out, but the court discusses the issues here arising on this change in the case. It talks about where departure causes no prejudice or where it will cause prejudice. In this case, the Court of Appeal...
Which paragraph are you
we're in the last part of paragraph 23, just after the quotation from Bellamy. And the court says that joining issue on amendments introduces in its proper context the issue of whether or not the party in question should be permitted to advance a case which has not hitherto been pleaded. And that goes on to say that was the true issue in the present case. And the recorder was not bound to disregard the admission, even simply because it could be demonstrated the facts admitted were not true. And this is, if you like, the next sentence is, if you like, the principle which I take from this, the task of the judge. He had to decide whether, having regard to all material matters, it would be right to permit the facts admitted to be put in issue. So that's the task of the trial judge, I say, when somebody seeks to give evidence inconsistent with their pleadings. And the first general point I make is that is a task for the trial judge. The trial judge is far and away the best position to make that assessment. In this case, the trial judge was aware of the pleadings, all the amendments, aware of what had and had not been amended. He'd seen all the relevant documents, and the documentary evidence in particular relevant to these admissions. He'd heard all the relevant evidence. He'd seen what evidence was and was not contested. He'd seen all the cross-examination on the timings. And he'd heard all of the relevant objections and disputes between the counsel about cross-examination on the timings. So I say the judge was in far and away the best position to make that assessment. And I submit, when considering the justice of the case and all material matters, the judge was entitled to permit evidence to be given that the active attempts took place from 4:30 a.m. to 5:30 a.m. And I'll identify a few reasons. First, very important, he had permitted the clinic to re-amend its pleadings without objection from Aeden's counsel. The clinic's re-amended defense put the time of active attempts in issue. We saw that, page 338. I won't take your lordships and your ladyship back there. That re-amended pleading makes a finding of 4:30 to 5:30 open to the court. And it's difficult to see how the judge, if he was permitted to make a finding of 4:30 to 5:30 on the clinic's case, would be bound to make a different finding against Dr. Abdulla. The second point I make is that Aeden's pleaded case did not identify what came to be the decisive issue on which the judge finally decided the case, the one that I articulated at the beginning. That decisive issue came to be to find at trial. So if we look at Aeden's statement of case again, beginning at page 225. And paragraph 18 pleads, so 226, I'm sorry, it's 226. Pleads a list of significant events and then pleads a chronology. And then we saw at 227, G and H, the pleadings to which Aeden would hold Dr. Abdulla. The significance of this part of the chronology isn't set out here in this statement of case. It's just part of the chronology at the moment. And then a significant averment is over the page at 228M, subparagraph M. So there's a pleading of no monitoring of fetal heart rate, but it's pleaded from 4:30 a.m., which is the time of the midwife's last note. And then when we turn to the particulars of negligence, they're at 232. I'm talking about Dr. Abdullah's particulars here, which begin halfway down the page.
Sorry,
So it's 232, halfway down the page, the particulars of negligence against Dr. Abdulla begin. But I'm going to refer to a particular one, which is 3 pages on, 235, and it's 8. So the particular of negligence pleaded against Dr. Abdulla in respect of monitoring is failure to monitor fetal heart rate in the 105 minutes before delivery at 6:15 hours. So that's the 4:30 a.m. to 6:15 a.m. period. Again, placing reliance on that 4:30 a.m. entry as the last record of monitoring. And we can see over the page, there's the causative relevance of that. Had monitoring been properly carried out, abnormalities would have been revealed. That's actually the only causation detail given. Because when we turn to the pleading on causation at 238, we can see it's very bald. Particulars of injuries. So by reason of the matter stated above, the claimant's being diagnosed with the following conditions. So causation of and mechanism of injury are not set out in detail in this pleading. And there's no identification of the length of time needed for PPHI, the minimum 1 hour. And there's no indication in the pleadings about causation that the alleged time of the end of active attempts at 5 a.m. is significant. And that seems to be because the end of monitoring in the pleading relied on is the nurse's 4:30 a.m. entry. And Dr. Abdullah's entry is discounted in the pleading. So that's why the 105 minutes has been pleaded. So what I say is the statement of case does not identify the issue in the way it came to be defined at trial. And that's relevant when we're talking about whether Dr. Abdulla has fundamentally departed from his case on the critical issue. And Dr. Abdullah's defense, well, I've shown you the admission already, but his defense to the monitoring allegation is at page 280 So he denies lack of monitoring. He says that fetal heart rate was monitored every 5 to 10 minutes by the midwife in his presence between 4:30 a.m. and the time was C-section.
Sorry, what paragraph?
It's paragraph 27, page 280. This is the defense to the lack of monitoring allegation. Incidentally, that last sentence on paragraph 27, in my submission, impliedly identifies 4:30 a.m. as the start of active delivery. It's when the change in practice of measuring starts, of monitoring. But the point I'm making about the pleadings, the number one point I'm making, is that the decisive issue wasn't defined on the pleadings. And if that's right, Dr. Abdulla hasn't been required to state his case on that decisive issue in the pleadings. And when he admits 4 a.m. to 5 a.m. as the hour of active attempts, he's admitting what on the pleadings is an incidental aspect of the chronology and not the decisive timing. The third point I make about the pleadings is that Dr. Abdullah's defense, in any event, is not an unequivocal admission that the attempts began at 4 a.m. and 5 a.m. because he pleads different facts about the timing elsewhere. So, page 292. Paragraph 3421 on page 292. He pleads the monitoring of the contractions, and then he pleads the time of full dilatation, 4:30 a.m. That's the last line in paragraph 3421. And then over the page at 3423, just the first line of that. The second defendant was summoned when the contractions were moderate or strong, and Mrs. Balwah's cervix was fully dilated. In my submission, those two pleadings amount to an implied statement that...
Sorry, 34.23. Yes, got the first sentence, sorry.
So, Dr. Abdulla was summoned when Mrs. Balwah's cervix was fully dilated. Yes. And he's just pleaded that that was at 4:30. Yeah. And this is based on the midwife's note.
The notes are not inconsistent with full dilation before 4:30, examination by the midwife, and he arrives perhaps at 4:30 and confirms that the patient is fully dilated. It's not that the moment of her being fully dilated is 4:30. It's just that nothing more happens. The midwife examines her and then he examines her.
That's right. Yeah, I accept that, my lady, yes. But the point I make about it is that 4:30 is the earliest point at which Dr. Abdulla will start attempts at delivery. And I say we get that from 3421 and 3423. So the defense is not an unequivocal admission that the attempts were 4 a.m. to 5 a.m. Here, the implied statement is they began at 4:30 a.m. The fourth point about whether it was just to depart from the pleadings is the timing of Dr. Abdullah's witness statement. So in his witness statement, he said that active attempts took place from 4:30 a.m. to 5:30 a.m.
Just going back to Lady Wise's point, we do have the entry in the medical records at 4 a.m. Where it simply says contractions 1 to 5 moderate, and there's no reference to the cervix being fully dilated at that stage.
No, so we'd have to infer that it's sometime between 4 a.m. and 4:30. I would say yes, my lord, yes. So the other point I make about the justice of departing from pleadings is the timing of the witness statement. Because Dr. Abdulla said in his witness statement that the active attempts took place from 4:30 a.m. to 5:30 a.m. That's page 771, paragraphs 36, 37, and 39. And the point I make about that is that evidence was filed and served in September 2016. Which was
Sorry, the date?
September 2016.
Thank you.
So that's 2.5 years before the eventual trial date. So if we're talking about prejudice and justice, I say that long notice of Dr. Abdullah's evidence is relevant. The final point I would like to make about the justice of departing from the pleadings is the complaint made by Aeden's counsel and the Court of Appeal that counsel was prevented from cross-examining Dr. Abdullah on his change in position. So I would just like to take the board to that passage in the cross-examination. It's 2174. And Dr. Powers is cross-examining. At line 18, you can see that Dr. Powers is cross-examining Dr. Abdullah on his pleaded admission. And then Dr. Abdullah's counsel intervenes at line 25. There's some quite lengthy interventions and a discussion. And then cross-examination of Dr. Abdullah starts again on the next page, line 9, and Miss O'Rourke QC steps in again, line 24.
Well, shouldn't an application have been made by Miss O'Rourke at that stage to amend the defence?
Well, my lord, I accept that would have been a better practice, yes. And then there are more points made on both sides, but it's at the bottom of page 2177, and over the page, sorry, it's at the bottom of page 2178 that Aeden's counsel sets out his position. And I take it up at line 30. And he says, turning over the page, I don't quite put it like that. I simply put it on the basis that this witness has been inconsistent in respect of the times that should be he has put down. I can deal with it simply by suggesting it to him, and he can accept it or not, and we can leave it to submissions. And the court says, I think it's best to leave it in submissions, Dr. Powers. And then the court goes on to say, line 12,
well, just analysing that, it would be counsel for Aeden could have said Miss O'Rourke should make an application to amend. Leaving it, and if, of course, that application had been successful, you could still use in cross-examination the inconsistency, and you could leave it to submissions if you wanted to. And
yes.
So
the point I'm drawing attention to here is that Aeden's counsel says to the court, he wants only to make the point in cross-examination that Dr. Abdullah's evidence and pleadings are inconsistent. So, and the point is made.
Well, I know Ms. O'Rourke in her submissions a little earlier had actually prayed in aid the inconsistency as a reason why he shouldn't be asked about it, because she was saying he signed a statement of truth on the witness statement, one set of things, and a statement of truth on the pleading, which it's contended is different. So it was a rather curious argument. At least I thought so when I read it.
Yes, I can see why your lordship might have found that curious, but
it just harks back to the basic proposition of if somebody is trying to introduce evidence that hasn't been pleaded, then you have an opportunity to object, and then you compel the other side to make an application to amend. If they
well,
wish
indeed,
to.
indeed, my lord.
And
it is a point I made in my written case that this witness statement was produced in September 2016. There was a round of objections to evidence by all parties, determined by the court on an interlocutory basis. There was no objection to Dr. Abdullah's evidence about the 4:30 a.m. to 5:30 a.m. Period. But all the various interlocutory objections to evidence are not in this record. I'll probably find reference to the chronology in the break, the chronology of interlocutory disputes. But the simple point I make about this, about what I've just shown your lordships and your ladyship, is that when it's said that Aeden's counsel was unfairly prevented from making the points he wanted to make in cross-examination, the single point he said he wanted to make was that these two documents are inconsistent, and that point is well made. So it's difficult to see what unfairness the Court of Appeal was holding against the judge in taking the position he did there at line 6. Yeah.
Your point is simply that there wasn't a whole chapter of evidence that was suppressed.
Yes. So I'll conclude on the question of timing by saying the judge in my submission was entitled to make the finding that he did, and I say he was right on the evidence of the notes that we saw, which he accepted as being accurate, and as he was entitled to do. Now, if I'm wrong about that, if the Court of Appeal was entitled to interfere and find 4 a.m., I will address quickly the questions of proof of injury and causation. The main point I make is, if I'm wrong, and active attempts began at 4 a.m. and ended at 5 a.m., then Aeden's claim becomes possible. It does not become proven. It remains to be proved. That's an unfortunate result 7 years after trial. But that's the approach the judge took. He didn't make other findings. That's where we end up. The Court of Appeal found the opposite. They found if active attempts began at 4 a.m. and ended at 5, they didn't say ended at 5. They said if active attempts began at 4 a.m., Aeden's claim was inevitably proven. And in my submission, that's wrong, because the Court of Appeal misunderstood the issues. So if I turn to the Court of Appeal's judgment on proof of injury and causation, beginning at page 124. So first with a recital of principle about the role of the appellate court, and then over the page you see the finding. It discusses some of the findings of the judge. And this is the passage that my Lord Doherty was referring to, I think, earlier.
Paragraph?
paragraphs 166 and 167,
Thank you.
where the Court of Appeal say they're not going to overturn findings of fact that the brain injury was not the result of the misoprostol overdose. And then, at the bottom of paragraph 167 is where I say the Court of Appeal begins to go wrong. There was, however, another allegation of negligence against the second respondent as it related to negligent management of the labour and delivery of the appellant. Well, it's true that was an allegation in the pleadings, but the Court of Appeal then goes on to say that the judge dealt with that allegation by dealing with the timing. The judge considered the issue of the time of arrival of Dr. Abdulla as it related to that allegation of negligence. And as I say, we've seen from my analysis of the judge's judgment, that's incorrect. The judge found one breach, that was the excess dose. When he turned to assess the timing, it wasn't to consider whether a further breach had been committed. It was to ascertain whether Aeden's injury could have occurred at the relevant time. And by reason of the timings, he found it couldn't.
So you say it was considered in the context of the...
Whether the injury could have occurred at the relevant time. That was the
as a result of the misoprostol.
Yes, and in this case, the judge was only considering whether misoprostol could have caused the injury. He wasn't seeking, by the timing question, to decide whether there had been further acts of negligence. So the Court of Appeal, I say, gets that wrong there at paragraph 168. And again, the misunderstanding is furthered at paragraph 169. So the Court of Appeal says the timing was relevant, would indicate whether Mrs. Balwah suffered prolonged second-stage labour. Again, in my submission, that's a misunderstanding of the issues, because it was agreed the active attempts lasted for 1 hour, and the judge was deciding when that 1 hour took place, with the end of that 1 hour being the relevant question as to whether further enough time was left before.
And just to come back to the earlier point about the cervix being fully dilated, that is different from active attempts. So it doesn't matter if the cervix was fully dilated before 4:30. What matters is the period of 1 hour of active attempt.
Yes.
Yeah.
So the question of timing was effectively, when did the active attempts begin and end? 1 hour. So it wasn't about whether second stage labour was prolonged. So what we see here, I say, is the Court of Appeal misunderstanding the issues that decided the case and that were before the trial judge. And then we've seen the Court of Appeal's reasons for overturning the judge's findings, and I'm going to move on to Court of Appeal's conclusions on that. Paragraph 183, page 129. So, and we can see that the judge should have found that Dr. Abdulla arrived at 4 a.m. This implied, as agreed between the parties, that second stage labour lasted from 4 a.m. to 5:30 a.m. and was sufficient for the condition of PPHI to bring about the brain damage. For the reasons I've explained, that's an error, because it was always the question of 1 hour of active attempts and when that hour began and ended. And then paragraph 186. So the same error is made with then somewhat short statement on causation. The inescapable conclusion is the appellant should have succeeded in establishing causation. And in my submission, that's wrong. The Court of Appeal did not understand, in my respectful submission, the issues before the judge and the issues on which he decided the case, and the questions that he did not decide. So I say the Court of Appeal's findings on proof of injury and causation cannot stand. My understanding of...
The case which is being put against you, as I understand it, is that there was a window of opportunity whereby the injury could have been caused during the period after the abandonment of the attempts at vaginal delivery.
Yes.
And the Court of Appeal at 183 is addressing something completely different.
Indeed, that's right. That's right, my lord. So the Court of Appeal's findings on proof of injury and causation, I say, cannot stand. The way I think that, the way I understand Aeden's counsel to be putting it now is that, leaving aside the way the Court of Appeal understood causation and proof of injury, once it's proven that active attempts began at 4 a.m. and ended at 5 a.m., Aeden's case on injury and causation is proven. In other words, what's said, as I understand it, from a finding that active attempts ended at 5 a.m., it follows that two matters are proven on Aeden's case. His injury not only could have been, but was suffered in the period between 5 a.m. and 6:15 a.m., and it was caused by Dr. Abdullah's excess dose of misoprostol. That's what I understand Aeden's case to be. In my submission, it's really difficult to see how that can be for these two reasons. First, the judge made no such findings. He expressly declined to do so. We saw that, paragraph 147. Second, both of those questions were very much in issue on the evidence. And I adverted to some of the evidence about the first question, whether Aeden did suffer that injury in that period between 5 and 6:15, when I went through the judge's summary of the evidence. But there were strong indications in the clinical observations which contradicted the possibility of a very recent catastrophic injury of the kind posited by Aeden's case. And so just by way of example, I'm just going to quickly run through a few of the judge's references. I think I showed you paragraph 40, so page 47, the judge's judgment. I think I showed you paragraph 48.
Sorry, page 47?
Page 47, paragraph 48.
Yes.
There's some of the contraindications contradicting the theory of a very recent catastrophic injury. Or over the page at 48, paragraph 50. That was in cross-examination of one of Aeden's experts. And then paragraph 62, which is at page 51. That was, yes, I showed the board that one. Paragraph 56. Again, recording some of the data. So this is paragraph 79 at page 56. Sorry, I may be confusing pages and paragraphs. Page 56, paragraph 79. Some of the doubts over timing of injury put to another of Aeden's experts. And then a very long summary at page 62 onwards of the evidence of Dr. Wilkerson, who was Dr. Abdullah's expert, on the unlikelihood of this injury having taken place immediately before birth, given all the contraindications. So paragraphs 93 to 100. So I'm hoping to demonstrate by this that the question of whether injury took place just before birth was very much an issue on the evidence and wasn't resolved by the judge. And in relation to the second question, whether an injury was caused by the excess dose of misoprostol, that too was very much an issue on the evidence. If we recall that in order to cause injury, an injury of this kind, the excess dose would do so by causing excessive contractions or extremely prolonged contractions or hyperstimulation of the uterus. And in her evidence, Aeden's mother complained of painful contractions beginning not long after the drug was administered, but that evidence was contradicted by the medical notes. And in cross-examination, Aeden's expert obstetrician was taken through those medical notes. Let's say we can begin at 1586. I'll take it quickly.
Sorry.
1586. This is the cross-examination of Aeden's expert obstetrician on the question of tachystole, which is the excessive contractions. I'll just advert to what's said there at lines 7 to 14. And then cross-examination on the clinic's notes begins at 1588. The bit that I'm going to concentrate on for the time being is at 1590, I think, line 34 onwards. Right. So this is.
So what page number, sorry?
So 1590, line 34, this is Miss O'Rourke, QC, putting to Mr. Giacimi the notes about mild and I think one every 15 minutes, beginning at 12:30. And making the point that this is inconsistent with excess contractions having begun before. And then in the middle of page 1591, lines 17 onwards, you can see Mr. Giacimi was constrained to accept that if the nurse's notes were correct, there could have been no tachystole in the period before contractions began to be measured by the midwife. So in other words, if the notes are correct, Aeden's mother couldn't have been suffering tachystole in the period 8 p.m. to 12:30 a.m. And from then on, the notes show contractions gradually increasing in a fairly expected fashion, gradually growing in frequency and strength, but no evidence of tachystole. And we can see the judge's record of that cross-examination. It's at page 54, paragraph 70.
So is the short point that the witness accepted that proposition?
Yes. And the short point I'm making is that, therefore, the mechanism by which Dr. Abdullah's negligence would cause injury was very much in dispute on the evidence, very much an issue. So both the essential matters Aeden had to prove were very much an issue, and the judge made no findings in Aeden's favor on either of them. And Dr. Abdullah maintained that position before the Court of Appeal, in my submission. It said as I understand it, that somehow the arguments before the Court of Appeal conceded the point on proof of injury and causation. That simply doesn't appear from Dr. Abdullah's written submissions at all. So I quickly show your lordships and your ladyship some examples. Picking up, so the Dr. Abdullah's submissions in the Court of Appeal begin at page 2493. I'll pick it up at 2498, paragraph 10. So, the court was guided by the eminent Queen's counsellors in this matter and understood this timing to be the critical qualification before going any deeper into analysing causation. In my submission, that's the same point that I'm making. And again, paragraph 11. This extremely complex and convoluted matter, riddled with expert evidence, essentially hinged on this one finding of fact before causation could be explored further. And then, executive summary, A. The timing was a precondition to determining if it was possible that the cause of Aeden's condition was negligence. And then 2523, paragraph 66, causation and proof of injury, or rather the possibility that injury actually happened just before birth, said to be still an issue. The claimant cannot establish when the injury occurred. Still cannot prove causation. Finally, for another example, these are just by way of example, but paragraph 102, which is 2542. And this is summarizing Dr. Wilkinson's evidence that we saw, all the contraindications against the proposition that injury happened just before delivery. So, on Dr. Abdullah's submissions in the Court of Appeal, there's certainly no indication that somehow the issue was narrowed and the essential matters to be proved were conceded. And I can make the same point very briefly about the clinic submissions, and I know my learned friend's going to have more to say about this, but 2395. .2.2. It remains to be proved, in other words. So there's no suggestion by the defendants before the Court of Appeal that these issues were dropped or would be resolved in Aeden's favour if the finding on timing was overturned. And that's where I leave matters. In summary, proof of injury and causation were not determined by the trial judge. They don't follow automatically from a finding that the active attempts were 4 a.m. to 5 a.m. So even if the Court of Appeal was right to overturn the judge on timings, and make its own finding that attempts began at 4 a.m., it was wrong to go on to find injury and causation proven inevitably in Aeden's favour. Those essentials remain to be proved. So those are my submissions on the Court of Appeal's errors, unless your lordships and your ladyship have any questions.
Thank you, Mr. Strang. We're grateful. Ms. Powers.
My lords, my lady, whilst the matter is still fresh in our minds, I want to clarify that it is not right properly to describe the allegations against Dr. Abdulla based only upon the allegations of the misappropriate dosage of misoprostol. May I invite you first to turn to the statement of facts and issues which are signed by all the counsel representing all of the parties in this dispute. And if you would be kind enough to turn to page 2753. You will see in paragraph 24.1 the overdose of misoprostol. I can very quickly deal with the issue of misoprostol whilst it's here. It cannot now be maintained on behalf of Aeden that the maladministration of misoprostol was in any way causative of the events from which he suffered. This is because in paragraph 136, which we will revisit of the judge's judgment, you will see that in paragraph 136C, the learned judge found that there was no evidence of any problem so far as fetal distress was concerned before Mrs. Balwah was transferred at the time of her full dilatation to the delivery suite. In other words, whatever time it proves in the end to be, but I shall say for these purposes around 4. And by 4 in the morning, the effects of misoprostol, such as they may have been, and there was some discussion about the effects upon Mrs. Balwah, they are not relevant. So issues of tachysystole or hyperstimulation of the uterus from that maladministration is not a matter which your lordships, my lady, need consider. But I started to deal simply with this point because it was fresh in the mind, and I ask you to look at the other agreed issues, subject, of course, to what was alleged against Dr. Abdulla. And you will see one which we needn't spend much time upon, 24.2, allowing fetal head to descend before active pushing. But more particularly, 24.3, an allegation against Dr. Abdulla failing to diagnose fetal distress during labour and delivery. My lords, my lady, the only way in which fetal distress can be diagnosed is by recording and monitoring the fetal heart rate. I'll come back to deal with that later after the short adjournment. But then you will see that is actually mentioned in 24.4, failure to monitor adequately in the 105 minutes before birth. That calculation is 4:30 to 6:15. And failed to determine at an appropriate time that a lower segment caesarean section was indicated. The allegations as agreed between the parties went well beyond misoprostol and into what is known as the second stage of labour.
Paragraph 24 sets out the particulars of negligence pled, but it doesn't set out the breaches which the judge found.
No, this is a statement of facts and interests and issues, my lord. And consequently, this is a recognition by the parties that these are the issues.
Well, I think my lord's point is that this is a recognition of what the pleading on behalf of Aeden contained.
Yes, yes, my lord, that is of course true.
But not necessarily, it would be said, an issue before us. And I think that's the
It's an issue in this respect that insofar as it may, I'm not suggesting Mr. Strang has in any sense sought to mislead you on this, but it's not right for it to be accepted by this court that the only allegation that was maintained against, and indeed, so far as the judge's own determination and subsequently the Court of Appeal's determination, that the only allegation is one which relates to the administration of the misoprostol.
But conveniently, the parties have set out at page 2759 the issues for the board to determine. And so I'm not certain why we're being brought to the pleaded case when we have what the parties have agreed were the issues to be determined.
Yes, indeed. Yes.
So, whilst it's fresh in our mind, what is the point that you wish to make in relation to the issues to be determined by the board?
Well, my Lord, obviously the issues to be determined by the board relate both to the nature of the injury, when it was caused, and the relationship between that cause, which Aeden alleges occurred during the second stage of labour, and the breach as alleged against Dr. Abdulla in respect of that period of time. My Lord, perhaps there's some value in just addressing this point.
Is that one of the issues
for
the board to determine the nature of the injury and its cause?
Yes. And the consequences of it. Did it err in entering judgment against Dr. Abdulla, finding as a result that the brain injury occurred in the second stage of labour, and finding as a result that the elements of negligence and causation were established? My Lord, if I may step back just for a moment on this issue of intrapartum or prepartum, which I shall address you at greater length. It wasn't my intention before the short adjournment to go down this way, but anyway, so far as the intrapartum passage is concerned, the time that we're looking at is the time of the start of the second stage, whenever that was. I appreciate that I need to address you in relation to it. But if this injury did occur in the intrapartum stage, if it did, it would have meant that in that intrapartum stage, there was a period in excess of an hour or thereabouts when the fetus would have been stressed by hypoxia. And that would have been demonstrated. I shall take you to the evidence on this, and there's not an issue on it. It would have been demonstrated by an abnormal fetal heart rate. That would have been acted upon and the fetus delivered before more than 60 minutes had passed of this occurring, whereby the injury would have been avoided. So that's the overall chain. And then the issue becomes, so far as negligence is concerned, what responsibilities Surgi-Med, the clinic, and Dr. Abdulla had during that second stage. Look,
sorry, don't look at my face to wonder whether I'm going to ask a question, but as you have looked at my face, I will. I had understood, I mean, this point boils down to a submission against you, that the learned judge made one finding of negligence against Dr. Abdulla, but the Court of Appeal added a second, which the judge hadn't made. I hope I've understood that correctly.
That, in summary, my Lord, is correct, because the allegations were there, the evidence was there, and their lordships in the Court of Appeal
made a fresh finding of negligence.
They made a finding that the responsibilities travelled through this period. The problem is that, my Lord, the judge recognized the duties which Dr. Abdullah had. I will come to deal with this, if I may, later, but the judge recognized those duties, and the question was whether or not they were breached. And there's only circumstance in which they would have been breached, and therefore material, is if those duties, had they been performed, would have stopped the injury occurring. So it's really a recognition of duty, and the duty becomes a breach once it's related to an event which takes place.
Well, I analyse it slightly differently. The duty is absolutely clear, and that is to take reasonable care in the circumstances.
Yes.
And the breach of that duty then has to be established. And you can establish it by failing to take records or make records or failing to monitor or a whole series of ways. And then you have to establish the next bit, which is that it causes that the breach has caused the injury.
Yes, because one has to measure the duty against the facts.
And as I understand it, the case that was being made was the breach of duty occurred here between 5 o'clock and 6:15. That was the case that was run before the judge.
Yes, except, of course, my lord, it isn't entirely the case that was run before the judge, because from the time that Mrs. Balwah was taken under the wing, shall I say, of the consultant at the time of being moved to the delivery room, it was her evidence. I appreciate that both her evidence and Dr. Abdullah's evidence were tainted, but it was her evidence, nevertheless, that there was no monitoring taking place. So the issue of whether or not monitoring took place is between 4 and 5, but if the finding of this court ultimately is that 5 is the end of the process, as my Lady Wise has identified as being relevant, if it is the hour of attempt between 4 and 5, then from 5 until 6:15 there was no monitoring. My Lord, unless you press me on it, I would ask that you permit me to unfold the submissions in the way in which I chose to do. I just felt that it was necessary to deal with the misoprostol, so perhaps you've all been assisted on that. And the issues which are in the SFI. Lords, my Lady, I just felt that perhaps it would be best to deal with most of the issues of law, if I can, I hope rather quickly, that have arisen. There are some important ones and some where there's no issue at all between us. And you may appreciate that Mr. Strang was in the case of Christo Gift only last year, and it does appear in your bundle. I'm not going to go to it specifically, but so far as the matter of constraints on appellate deference is concerned, Lord Burroughs cited in Christo Gift and adopted Lord Justice Lewison's criteria set out in Volpe, which you'll find at 3050. So I have nothing further to say in respect of that. There isn't any issue between the parties, as I discern, on appellate deference. There is, however, an issue on the law of amendment. And I'd invite you first to look at, and this court, definitely constituted, has seen this issue of the requirements of Part 20 of the Consolidated Civil Proceedings. You'll find this on 2875. I may briefly take you through this. And the reason, my lords and my lady, that we're seeking to do this is to draw out and emphasize a distinction which exists between the procedure in Trinidad and the procedure in the United Kingdom. which Mr. Strang's already indicated, is a rather more liberal in its approach. But you'll see this is the state of the pleadings at the time of this case. So an amendment to a statement of case can be made at any time prior to a case management conference. It doesn't apply here. The court may give permission to change a statement of case at a management conference. The court shall not give permission to change a statement of case after that case management conference, first case management, unless it is satisfied. And there are two what are known as threshold elements there. There's a good explanation for the change, and the application was made promptly. Those thresholds have first to be crossed before there's any consideration of the discretionary factors which follow. My lords, this came about, as this court will know, as a consequence of the decision in Cibalak, or Bernard and Cibalak, which you will find at 2904. This was an unhappy case in that Charmaine Bernard brought an action on behalf of the estate and dependency against Ramesh Cibalak for the death of her husband. And she'd set out in her pleadings an insufficient amount of information. And in particular, she did not plead special damages and lost years, and she sought to do that. She was granted permission to do so by the judge, but it was reversed by the Court of Appeal, and so it came before another constitution of this board. The board held that it was necessary to make an amendment, and it supported the Court of Appeal's decision as to the process by which that should be done, and the reasoning behind it. Lords, I invite you to turn to 2917. And forgive me one moment, you need to turn back to an earlier paragraph in this court's judgment, paragraph 16. I say this because it's a necessary part of the submissions which will follow on other matters. You will see that this court said that a detailed witness statement or list of documents cannot be used as a substitute for a short statement of all facts. But the principal purpose of turning to this paragraph 31, which you find on 2917, is the purpose which is recognized by the board of the necessity of Part 20.13 as it was. At the time of this judgment, the format of 21.3...
It was stricter than the current format. It was stricter than the current
It was stricter, yes. So much so that this court, in the end, having recognized that it was bound, because obviously there was underlying justice in this case, that this lady should be permitted to make a claim in the way in which she did, but for whatever reason, it didn't happen. But she couldn't, under the strictness of the rule as it then stood. And just as a matter of looking at it, I addressed your attention, of course, right at the beginning of the parts of the authorities to this rule, which you find, as I said, on page 2875. On the following page, there's helpfully set out in the consolidated rules, that is at 2876, the rule as it stood before the amendment. So what happened is that the Rules Committee then recognized that there needed to be some relaxation and introduced the 21.3 13A, which were the discretionary criteria. And it's in the context of how the courts since then have interpreted the strictness of the requirements so far as amendment is concerned. Lord, the next authority I'd like to invite you to look at is the Gulfview and Teixeira case. This was a decision of this board, differently constituted in 2022, although my Lord Stevens, together with Lord Pentland, gave the judgment of this court in that case. You may remember this case, my Lord.
Page?
Sorry, it's at 2931. 2931. It was a very sad case, another very sad case, in that Kiran Teixeira was the widow as a consequence of the death of her husband from an operation called a transurethral resection. And he died in the Gulfview Medical Center as a consequence of a massive amount of post-operative hemorrhage and maladministration, as the judge found, of fluids and so on, whereby during a long, well, not a terribly long post-operative period, he eventually succumbed. Now, the matter came to this court because of the manner, effectively, in which the pleadings had been made and accepted by Gulfview. And it's not entirely incidental that the leading counsel, the late Mary O'Rourke, who represented Gulfview, because there are comparisons, very interesting comparisons between the development and the reaction of this court to a pleading situation. Mary O'Rourke, QCs, I think she then was, advanced a case which was contrary to the pleaded acceptance. She and the other two defendants at the time, the anaesthetist and the surgeon, were alleged to have had a duty to ensure essentially all aspects of care. Now, this, as Ms. O'Rourke subsequently admitted to this board, was a mistake in the pleading, and that during the course of the case before the judge, Kukaram, she had embarked upon a cross-examination of witnesses on the basis that the Gulfview Medical Center responsible for the nurses did not have any responsibility in respect of the actions of the surgeon or the anaesthetist. And indeed, subsequently, she made submissions in exactly the same format. And the problem was that she was working with a pleading in which it had been admitted that Gulfview owed what was interpreted subsequently as a submission that this was a non-delegable duty placed upon the health center, the medical center. And that was recognized in the judgment of the judge. Could I invite you to turn to 2940? And to paragraphs 32 and 33, which my Lord Stevens set out here as being the basic problem from the judge's judgment. 2940, paragraph 32. The judge is saying, however, Gulfview has persisted in its closing submissions to insist that there is no duty on Gulfview in relation to their nursing staff. My Lord, if I just stop there for a moment, you will appreciate that there was raised in this litigation, it's not active, and should never perhaps have been pursued before the Court of Appeal, that there was a non-delegable duty placed upon the clinic here in respect of the actions of everyone else. It failed, quite rightly, before the Court of Appeal and wasn't persisted. But the underlying point here is that the nursing staff and the hospitals do not employ or aren't otherwise responsible for the anaesthetists and the surgeons and the other people who are independent contractors. But in this case, there was the acceptance of that responsibility. The judge went on similarly, counsel for Dr. Roopchand, who was the anaesthetist, took the cue from Queen's Counsel to assert that his duty was restricted to only that of administering the anaesthetic. And as the judge concludes in that little passage, but these submissions certainly contradicted their pleadings. And then in conclusion, as was cited, the pleaded duty, at the bottom of the page, 5 or 6 lines up, was admitted by these defendants, and it included, critically, the monitoring of Mr. Tashira's blood loss, the containment of his blood loss, the management of the patient in the post-operative care to safely transfuse large quantities of blood products and carefully manage the same. There simply is no plea by Gulf View that its duty or role was limited to support, service, or providing accommodation. And as the judge finishes that by the important observation, which will become more apparent with further cases I want to refer to, what was going on by way of this cross-examination was really irrelevant, because it doesn't advance the defendant's case against the backdrop of its accepted duties of care. So, look, this case is almost a perfect example of the difficulties that parties get into when they've made admissions in their pleadings. Various attempts were made, including there was an attempt made in this litigation of Gulf View to make an amendment on behalf of Gulf View. It wanted to sever itself from the admission which had been made. It embarked upon an amendment at the beginning of the trial before the judge and then abandoned it. That was subsequently recognized as the problems which arise in a situation where one wants to amend and the likelihood of the amendment being permitted without an agreement is not going to result in a favourable outcome. Because, of course, once a situation arises, just say this before we adjourn, if I may, once a situation arises where there's an admission, it's extraordinarily difficult if you want, on the one hand, to say, well, you know, it doesn't matter, it's a peripheral, you can derogate, you can do all sorts of things. And on the other, which is accepting that there is a need to amend, and then failing to be able to do it. Because that's exactly what happened in this litigation before the Court of Appeal as an interlocutory matter. Because in that situation, it then becomes indelible that the parties are absolutely bound solidly to what is in the pleadings. There's been an attempt to amend them, the amendment has failed, you're stuck, if I may put it that way, with what you pleaded.
I think the facts of that case were somewhat different, and the whole trial had proceeded on this basis without any amendment being made. And indeed, even down to the detail of what blood was being transfused.
Yes.
It's an example of the exercise of discretion in relation to amendments.
Yes. Yes, it is, and it's also an example of how a party has to be held to its pleaded case, as it was.
I don't think I ever said that in all circumstances, a party has to be held to his pleaded case.
Well, that's a
Unless
matter,
you- unless you
that's a
can
matter
put me
which
to
I
the
will develop,
part of
if
the
I may, after
judgment.
the short and German, by looking at the other authorities. But the short answer to that, my lord, is that in Trinidad, the pleading has to be amended.
The justice of that case was all one way.
Yes.
So,
Thank you. If that's a convenient moment,
Yes.
we'll rise now and we'll sit again at 2 o'clock.